let's get started. I'm Laura Livingston. I'm a regional director at Over Zero, and am very excited for everyone to join us for the third of a series of seminars on countering online hate and its offline consequences. This series is hosted by the Media and Peacebuilding Project at GW School for Media and Public Affairs and Over Zero in partnership with the World Bank. And for this series, each seminar reflects individual chapters in a forthcoming book on the same topic, countering digital hate and its offline consequences. And the book has sections addressing the dynamics that contribute to the spread and resonance of online hate speech, interventions to address hate speech and its broader societal impacts, media sector reforms, and regulatory and platform governance reforms, of which this presentation is part of that section. Our hope for these seminars and for this book more broadly is to merge insights from cross-disciplinary research and global practice to spotlight a spectrum of interventions and broader reforms that can be implemented to mitigate the spread and offline impact of hate speech in conflict-fragile settings. For today's seminar, Dr. Talita Dias will present on her chapter, which is on tackling online hate speech through content moderation, the legal framework under the International Covenant on Civil and Political Rights. Dr. Dias is a research fellow in law at Jesus College, Oxford, as well as a research fellow with the Oxford Ethics, Law, and Armed Conflict. Her current research focuses on the application of law to new technologies, the international regulation of online hate speech, and states' obligations to prevent and redress harm in the cyber context. I will hand it over to Talita in 1 second, but just one note on timing and housekeeping. We have about 30 to 40 minutes for the presentation, and then we'll use the remaining 20 or so minutes for Q&A. If any questions or points of discussion come up for you during the presentation, please write them in the chat and we will address them after. And then also this is being recorded, so just know that as well. So without further ado, I will hand it over to Talita.
Thank you so much, Laura, for the kind introduction. So I'll start by sharing my screen. I've prepared some slides to guide us through the presentation today. I hope everyone can see them. Let me just put them up on presenter mode, so that's great. So, as Laura said, my presentation is about my chapter, which is entitled Tackling Online Hate Speech Through Content Moderation, and I'm focusing on the legal framework under the ICCPR. So this chapter is based on my ongoing research at Jesus College and the Oxford Institute for Ethics, Law, and Armed Conflict into, more broadly, the application of international law to new technologies, including the internet and other information and communications technologies. And it's also part of my own project into online hate speech under international law more broadly. So that project is called Just Speech. And yeah, there is a website that I've prepared with all the outputs of this project. I am also in the process of preparing a mini documentary on online hate speech and international law. So I'm very excited about this. And yeah, this chapter was actually the very first output that I produced as part of this chapter, and I've chose to focus on the ICCPR, the International Covenant on Civil and Political Rights, because this was my starting point in my own project, and also because, as we will see further on during the presentation, the ICCPR is one of the most important international documents dealing with this topic. So let's move on to the outline of the presentation. I'll start by briefly talking a little bit about the motivation behind this research, this chapter, the focus of the chapter, and as I said earlier, why the ICCPR, but also why content moderation. Why is this chapter about content moderation and the ICCPR? Then I'm going to talk a little bit about some background and in particular, some of the challenges of moderating online hate speech, as they relate, of course, to international law. And then I'm going to go to the heart of my presentation and the heart of my chapter, which is a taxonomy of online hate speech and measures to counter hate speech, including content moderation, but other measures as well, under the ICCPR. So basically looking at the ICCPR in depth and trying to interpret the ICCPR, the relevant provisions to this new phenomenon. What can we learn from it? What can we devise from it? And that's what I came up with, this taxonomy of online hate speech. And then I'm going to talk a little bit about applying basically the legal framework that I've developed in fragile settings. So what measures of content moderation can we adopt, should we adopt in these settings? And then I'm going to just finish with some concluding thoughts very briefly. So starting with the motivation, and in particular, why the ICCPR. So basically, as I hinted at earlier, I chose to focus on the ICCPR because the ICCPR is a quasi-universal treaty, a binding legal document agreed upon by states, currently by 173 states, if I'm not mistaken. So it's a widely recognized legal document that obliges states to protect and respect human rights. And also, most of the ICCPR's provisions, at least the essence of these provisions, and including the provisions that are most relevant to the topic of online hate speech, that is non-discrimination, freedom of expression, and protection against incitement, these are part of customary international law. So they bind all states around the world. So the ICCPR is really the most important human rights treaty that we have because it applies to a significant number of states, if not all states around the world, via customary international law. But my work and my chapter is not just about states, even though the ICCPR is a treaty binding states first and foremost. It's also relevant for companies. It's relevant for companies because first and foremost, company social responsibility. So those voluntary commitments that companies have taken on under the Ruggie principle. So the principles, the guiding principles on business and human rights, they reflect to a large extent the ICCPR. So the ICCPR is also a baseline that undergirds the social responsibilities of corporations also in this area, in the digital environment, and as it pertains to online hate speech in digital platforms. And also, for companies and also other non-state actors, the ICCPR is an important document also on a policy and on a legal level, because it provides these actors, these various stakeholders, including, as I said earlier, companies, but also civil society organizations, academia, activists. It provides them with a common language which is universally accepted, and which allows them on both a policy and a legal level to advance responsible behavior on digital platforms to counter hate speech. So looking forward, how can we prevent hate speech from arising in the first place? How can we advance state responsible behavior of states, users, and other stakeholders like companies in this digital space? And the ICCPR is also an important legal and policy tool to challenge wrongdoing. So wrongful content takedowns, for example, wrongful speech acts that amount to online hate speech, prohibited online hate speech, for example, by companies. So for example, if you've got a state actor that is directly expressing hate speech, hateful rhetoric in a certain state, in a certain online platform, platforms can challenge that by using the ICCPR. And at the same time, if states aren't doing much, so for example, if there's a legal gap when it comes to online hate speech, companies and also civil society can make use, can refer to the ICCPR to fill those gaps and demand state action. And finally, The ICCPR is important as a legal basis for advocacy and litigation. So in many states, it is possible to invoke provisions of the ICCPR as human rights provisions to litigate against wrongful conduct, including hate speech acts and wrongful takedowns of these alleged acts. So it's a really important document for all stakeholders. And so this is why I chose to focus on the ICCPR first and foremost. Now, moving on, then why content moderation? Why did I focus on content moderation rather than other measures such as, for example, prevention, educational campaigns, and so on and so forth? So the first thing to bear in mind when we talk about content moderation is that content moderation is not just about content takedowns. So when we think about content moderation, we think about those people, outsourced people working in terrible conditions, just filtering over, looking through millions and billions of posts every day and taking down content that they think goes against, for example, company standards and so on and so forth. But this is not all that content moderation is about. And in fact, it's just a tiny, tiny piece of the puzzle, because content moderation is more broadly defined as content governance. So it's about trying to find ways, different approaches to navigate the tensions between freedom of expression and protection against other rights that might be harmed by speech act. So it's about different measures, a range of measures to manage what content we see, what content is amplified online, what content is disseminated, what content comes first on our feed, what content is redacted, what content is labeled or tagged, and so on and so forth. So it comprises a range of measures, and it's not just about content takedown. So again, content under the umbrella of content moderation, we can fit a number of different measures to deal with different types of content online. And also there are various approaches to content moderation. I'm sure you've heard of decentralized, centralized content moderation. So where the companies themselves do the moderation, or when the users do the moderation. There's automated moderation, human moderation. So there's a variety of faces to this tool that we call content moderation. And as I said earlier, content moderation is a key tool to help us navigate those tensions, right? It's a middle ground, if you will, between protecting the rights of others, protecting people from discrimination, protecting people from harm, protecting the reputation of people, and also ensuring freedom of expression online and offline. So it really helps us to strike that balance and helps us to move away from binary approaches that are currently present in many countries. For example, the UK, where I am at the moment, where you either have a content being taken down or it's left up. So it's either one or the other. And that's really not what the ICCPR and human rights law more generally are seeking to achieve and to convey when it comes to speech and online hate speech in particular. And so relatedly, content moderation is necessary to implement the ICCPR, because as we will see further on in this presentation, the ICCPR provides for a number of measures that need to be adopted on the basis of what is necessary and proportionate to protect the rights at stake. So it really is a way to implement the necessity and proportionality criteria within the ICCPR, which we find in the right to freedom of expression. So any limitation to the right to freedom of expression needs to be necessary and proportionate, and content moderation really helps to implement that in a balanced way. So this is why I chose to focus on content moderation. But again, just a caveat, this is without prejudice to other tools that might be helpful to tackle the phenomenon, especially those tools that act at the root of the problem. So preventive more preventive approaches, for example, educational campaigns, awareness raising. All of these approaches go together. They go hand in hand to tackle the problem, either as a form of prevention, as a form of mitigation, or as a form of remediation, right? So we need to think holistically, and content moderation is just one piece of the puzzle. Now, so just a little bit of background on the challenges of moderating online hate speech in this digital age where we've got everybody hooked up in their phones, and now we've got metaverse, and now we've got these Facebook files and the revelations that companies are not really trying to have our best interests at heart and disseminate and amplify whatever profits them. So this is a really big challenge for us. But what are the main challenges of doing that under international law? So the first one is speech, although we talk a lot about hate speech today, and we've talked a lot about it in the past, it's not really a technical legal term. It's not found in any treaty, customary, or even legal official documents that have legal value per se. So it's not really a technical term, and it's not defined. So that really leaves us with a little bit of a gap, with a little bit of uncertainty as to how we can tackle the problem from a legal and international legal perspective. So hate speech, it's not a technical term, but it's more, it's better framed as an umbrella concept. So it has been used in, common language, journalistic language, academic language. But if you could look at it from a legal perspective, it's better defined as an umbrella concept that encompasses a number of different types and forms of expressions of hatred, animosity, prejudice, discriminatory language that are based on a protected characteristic, because this is what the ICCPR is trying to protect when it comes to non-discrimination, right? Protected characteristics. And there are a number of these protected characteristics, for example, under Article 26 of the ICCPR. So we've got color, we've got race, ethnicity, gender, language, nationality, religion, social origin, birth. So all of these characteristics are protected. And so at least from a legal perspective, if you've got expression that affects or infringes upon these protected characteristics, you can consider that to be hate speech for the purposes of the ICCPR, if you will. Now, we've always had a big challenge with hate speech and other types of harmful speech because online and offline, right? Because it's a question of back to important rights. On the one hand, you've got free speech, which in North America, for example, and in Canada, and on that side of the Atlantic are really fundamental freedoms, right? They're sacred. And so everything that limits speech is really exceptional. And on the other hand, we've got the need to protect other rights and interests and values that can be harmed or infringed by free speech. And these are, as I said earlier, non-discrimination, the reputation of people. So for example, libel, defamation, all of these things harm the reputations of others. And also, more importantly, we need to protect the health, the dignity, and the life of individuals that are somehow affected by hate speech, because as we all know, hate speech might lead to real world consequences. And so we need to find the right balance between these values. So this has always been a fundamental question, a fundamental dilemma in all democracies around the world. I mean, here on this side of the Atlantic, in Europe, and also in Asia, people tend to be a bit more protective about non-discrimination and other rights, whereas in America, people tend to be a little bit more, they tend to err on the side of freedom, if you will. So this has always been controversial, but online, the challenge is compounded because you've got a pervasive means of communication. The internet is everywhere, as I said earlier. And it's now, we've got cameras, gathering our data on a daily basis, producing more content, influencing us more directly. And so we've got a scale never seen before of dissemination of harmful content, including online hate speech, or no curation. So the directness with which speech is published out there is never seen before. And also the speed is, never seen before as well. In seconds, less than a second, one single harmful instance of online hate speech can reach thousands and hundreds of thousands of views due to, for example, recommendation algorithms of these social media companies. So these are the challenges. And as I said earlier, online hate speech and other types of harmful content, they lead to real world consequences that infringe upon the rights of other individuals, and which may actually amount to even more serious things like international crimes, such as genocide, crimes against humanity, and armed conflict, especially in fragile settings. So we've got a big problem in our hands, and we need to figure out ways to tackle it, and hopefully international law will be useful. So the heart of my chapter and my presentation is this taxonomy that I've developed of online hate speech under the ICCPR. And it basically draws on the language and the purpose, the object and purpose, and the context of two key provisions in the ICCPR. So these provisions are Articles 19 first. So Article 19 is, as we all know, the provision in the ICCPR that protects the freedom of opinion, but also, and most relevantly for us, the freedom to receive and to impart, to express, to send out information in all kinds and all forms. So online, images, symbols, everything that is information, we are free to receive it and to express it. So freedom to receive information is also important, because sometimes we don't think a lot about it. But when it comes to censorship, for example, if you limit a certain kind of expression or content online, you're not just infringing upon the rights of the person who has posted that particular content online, if it's been wrongfully taken down, but you are also infringing upon the rights of other users, the audience, to see that kind of content. So it's got two sides, the right to freedom of expression. And most importantly, in the context of online hate speech, we've got Article 19, paragraph 3, which provides for the limitations to this right. So there is a well-known 4-part test for any limitation to the right to freedom of expression. And any limitation needs to be made by law. So that's the legality requirement. It needs to be legitimate. So there has to be a legitimate purpose to the limitation. So these are listed in Article 19. So to respect the rights and reputations of others, to protect national security, to protect public order, public health, or morals. So it has to be one of these purposes. Otherwise, you cannot limit speech, even online hate speech. And it has to be necessary and proportionate, as I've mentioned earlier, which is why, again, I decided to focus on content moderation, because it really allows us to calibrate the measures that we adopt to tackle online hate speech. And the second relevant provision that I looked at was Article 20 of the ICCPR, which first and foremost prohibits war propaganda, so unlike Article 19, which gives states the right to limit speech, Article 20 requires them to prohibit war propaganda, and most importantly, it requires them to prohibit advocacy of national, racial, or religious hatred that amounts to incitement to either discrimination, hostility, or violence. So there is an obligation here on states to prohibit that. It's not any kind of online hate speech, as we will see later on, but it's this particular kind of hate speech, online or offline, that needs to be prohibited by law. And so I've looked at these two provisions, building on the reports that we've had so far from the special rapporteurs on freedom of expression, and also the work of the Human Rights Committee on the topic. So I've built on what they've done so far, and I've tried to provide a little bit more granular advice, a little bit more granular proposals on content moderation specifically. And this is why I came up with this taxonomy of online hate speech. And based on this taxonomy, I have kind of like put together a number of proposed measures that fit each of these categories better in trying to give effect to the relevant provisions of the ICCPR relevant instruments, which I won't go into right now. But anyway, the three categories are prohibited, limited, and free speech. So it's pretty straightforward. We've got these three types of online hate speech. So hate speech and online hate speech are not, cannot be fit into one single box. It's not a one size fits all thing. It's a little bit of a puzzle, but we can roughly classify them into, legally at least, in these three categories. And each category deserves different measures. So prohibited hate speech, as it's quite clear by now, is that kind of speech that states must prohibit by law. And that is first and foremost, according to Article 20 of the ICCPR, advocacy of hatred, amounting to incitement to discrimination, hostility, or violence. So the grounds of discrimination, hostility, or violence that Article 20, paragraph 2 provides quite limited. So let me go back here. So you can see it's about nationality, race, and religion. But an interpretation of this provision, Article 22, in light of other provisions of the ICCPR, and I'm referring specifically to Article 26, which is about non-discrimination, would necessitate a broader reading of these grounds of incitement that states must prohibit. Because Article 26 is about non-discrimination. So why is the ICCPR giving preferential treatment to some categories and not others? So my view and the view of the former Special Rapporteur on freedom of expression is that the categories of the basis on the protected characteristics on the basis of which incitement to discrimination, hostility, or violence must be prohibited should be expanded to include all those grounds that are listed in Article 26. So race, color, gender, language, religion, political opinion, social origin, property, birth, sexual orientation, gender identity. So all of these grounds should deserve protection under Article 22, in my view at least. And then the second type of prohibited online hate speech, which is not strictly found in the ICCPR, but it's found in another convention, a related convention, that's the International Convention on the Elimination of All Forms of Racial Discrimination. So racial discrimination has a little bit of an elevated status among treaties protecting against discrimination because of the history of racial discrimination that we've had in the past. So it makes sense to treat racial discrimination a little bit more harshly. And so Article 4 of ICCPR requires states to prohibit propaganda that is based on ideas or theories of racial or ethnic superiority, or ideas that try and justify or promote racial hatred, discrimination, or incitement. So it's quite broad, and it's about race or racial or ethnical discrimination. But we do have to bear in mind that all of these types of prohibited online hate speech, they're still contextual. They're contextual because we need to look at the language and context. Human language is contextual. So context is key to understanding content. So content is contextual. And so, for example, even terrorist content and nudity, for example, we've got AI software say, well, we can, take down terrorist content and take down nudity and stuff very quickly. But even nudity can be ambiguous. For example, a breast cancer campaign showing a breast is not something that is offensive, for example, at least for some. And so everything is contextual. So we still need to interpret these types of prohibited online hate speech in context. Another example is if you've got a protest, somebody posting something to protest an instance of online hate speech, that post itself will not be prohibited speech, prohibited online hate speech. Or if you've got people making a warning, okay, guys, please be careful. There is a crazy person saying online that inciting people online to commit violence against a certain group. That is a warning, so that wouldn't be prohibited speech. And also, for example, for academic reference, if you cite a certain post that contains online hate speech, prohibited hate speech for academic purposes, that also wouldn't be prohibited, also depending on context. So some examples that I've put here, so we've got some magazines and cartoons from back in Rwanda from the 90s that were clearly inciting people to kill others from the Tutsi minority. We all know that, but more recently, we have examples of posts that are inciting violence and calling for the Rohingya to be killed. These have been taken down, and even nowadays on Google, it's hard to find these posts. So I saved them back when the Rohingya crisis was at its peak, and luckily I still have them, which is also an issue, right? Another issue, deleting these posts and not storing them for evidentiary and academic purposes. And more recently, last year, and I've written about this, when we had the Euro 2020 finals, which happened in 2021 between Italy and England, we've had a storm of racist abuse online, and we had clear examples of incitement to racial violence and hatred. But as I said earlier, the original posts themselves would be prohibited for hate speech, but not the posts that are actually warning against these posts. Now, in terms of moderating prohibited speech, as I've mentioned earlier, so for racial discrimination, there's mandatory criminalization by law. So that's what the International Convention on all forms of elimination of all forms of discrimination says. And the ICCPR also, for other forms of incitement to hostility, violence, or discrimination, not just based on race, but other grounds, must be prohibited by law. These acts must be intentional, because here you're talking about prohibition, you're talking about very serious sanctions, so they have to be intentional. And criminalization for these prohibited speech acts that are not racial discrimination are only applicable when it's necessary and proportionate. So remember that Article 19 requires every measure limiting speech to be necessary and proportionate. So states must only criminalize speech acts, online hate speech, if it's necessary and proportionate. And so taking into account the seriousness of the act, the context, the speaker, the content itself, the audience, and the means. And otherwise, they can just prohibit the act by applying civil or administrative sanctions for other types of incitement that are less serious. But alongside legal prohibitions, you've got proactive moderation as well. So this is something that I have advocated for this category of speech as soon as the content is published. And proactive moderation could happen, should happen when it's manifestly clear that a certain content is prohibited. Granted, these scenarios of manifestly clear prohibited speech will not be very common because of the contextual nature of language, right? So there will always be some doubt. So it's only if, for example, in the past, a certain social media company has found that same picture, that same post has been ruled prohibited speech, then it should immediately take that down. So only if it's manifestly clear, prohibited speech should be taken down. But as I said in my chapter, as I argue in my chapter, all of these decisions need to be subject to human review, even if they're initially taken down by AI, because AI will never understand context, at least not now, not in the state that it is at the moment. So there has always to be human review. In case of doubt, which will be most cases of prohibited content, content should remain, but less restrictive measures should be adopted. So for example, deprioritization, redaction, tagging, a message of non-endorsement. And then when a human reviewer looks at the content and assesses whether it is prohibited or non-prohibited, then if it's prohibited, then the content should be taken down. And if it's not prohibited, then the other measure must remain. And as I've argued in my chapter, judicial review should always be available. And this is because of the right to an effective remedy under Article 2 of the ICCPR. So judicial remedies are the best ways to afford victims of human rights violations an effective remedy. So judicial avenues should always be available to challenge these decisions, which is something that not many people talk about, but the judiciary is also responsible for that. Why so harsh? Why take down when it's manifestly clear that you've got prohibited speech? The justification is that these kinds of speech acts, incitement, they are so proximate to actual physical or mental harm and human rights infringements that the balance, in a way, it tips in favor of protection. It tilts in favor of protection rather than freedom. It justifies, this harsher approach is justified by the risk of harm here. And also advocacy or incitement are not just speech. And we know this because perpetrators are not always resilient. They're not always aware that they cannot commit actual acts of violence and discrimination. And victims are not always empowered to speak out. And actually, if you let these kinds of speech proliferate online, that might have a chilling effect on victims' own rights to freedom of expression. So it's in a way, a measure to protect freedom of expression itself of victims. Right, moving on, limited online hate speech very quickly. So these are short of incitement, offensive, hateful, or discriminatory content targeting individual or group characteristics, the same characteristics, protected characteristics that I've mentioned earlier. And they deserve limitation because they fall under those criteria in Article 19.3. So they are legitimate to protect or respect the rights and reputations of others, national security, public order, health, or morals. And these grounds must be strictly interpreted because you're talking about a limitation to a fundamental right. And it's necessary and proportionate in the circumstances to limit those speech acts. So just a few examples, recent examples. So we've had also in the context of the Euro 2020 finals, posts that were telling the players to go back to Nigeria, get out of my country. So it's not the N-word, and even the monkey emoji. So these things are not directly incitement, but they can still be limited in the circumstances because, for example, in England, there has been a systemic context of abuse online. And so these kinds of posts should be limited somehow. A redaction here would suffice, in my opinion. Another example is this criticism of Muslim Brotherhood. And this is not also inciting directly violence, but it's offensive and it should be limited because of the circumstances of political division in the US, for example. And another example here is this post from Al Jazeera Arabic, where there's someone questioning, so it's basically Holocaust denial. In some contexts, Holocaust denial should be limited because of the historical context. So for example, in Europe, many countries prohibit Holocaust denial, and rightly so. Now, what kinds of moderation measures do we adopt for limited speech? So it's for states not companies, to define that in a legal framework. So this is really important. So it's not enough to have company standards, guidelines, community guidelines to fulfill to implement the ICCPR when it comes to limited speech. States must clearly delineate what is limited speech and what measures are applicable to limited speech. So states must do that because censorship is a state prerogative, but they're not required to limit speech. So it's a prerogative, it's not an obligation. And it depends on, as I said, legitimacy, legality, necessity, and proportionality. And here again, the balance tilts in favor of freedom rather than protection. Basically, in terms of measures, specific measures, you can have prohibition and sanctions by law in extremely serious cases. Less serious cases should be limited by measures authorized by law, such as deprioritization, tagging, labeling, non-endorsement, redaction. And which measure we choose should depend always on necessity and proportionality. And basically that means in the context of digital platforms, the historical and social context, the speaker. So if the speaker is very prominent, then that raises a red flag here. So maybe we should limit if the speaker is very prominent, if he's got or she's got or they've got many followers. The audience, if the audience is resilient or vulnerable, then that will change the approach in terms of content moderation and the actual content itself, whether it's directly affecting, it's directly targeting people or not. And the means, obviously, if you are on a social media platform that is that has a very large user pool, then obviously then that content will be more deserving of limitation.
Talita, I'm so sorry to interrupt. I just want to do a time check.
Yeah.
5 minutes before getting to the questions.
Yeah, so I'll wrap it up. So basically, just to wrap it up here on limited speech, these are difficult decisions as always, because again, content is contextual and these involve moral judgments. And so what I propose in my chapter is that in these kinds of cases, that there must be human moderation, no AI. And as far as possible, decentralized moderation and the utilization of consensus algorithms to kind of have juries deciding, peers deciding on these kinds of cases with decisions implemented automatically on the platform. And also, these decisions should always be open to judicial review. Finally, free speech. Free online hate speech is the residual category, and that's content that is neither prohibited nor may be limited, and it's usually directed at institutions, not persons. And it's permitted as a general rule, but context is still key for classification. So for example, cartoons, religious cartoons, there are many. I won't linger too long here, but because you've seen these cartoons already, but yeah, religious, satires, criticism of institutions, states, governments, these things are not prohibited nor should be limited, depending on the circumstances and the context again. And then the measures for these kinds of speech acts are a little bit more flexible and more preventive, such as digital literacy, education, algorithmic changes, counter speech, empowering users, auditing, promoting smaller platforms, and etc. This is a summary of a matrix of my measures, so I won't stick too long here. If anybody is interested, I can send the slides to them. And fragile settings, just the core message is that there's no one size fits all approach, right? As we saw, we need flexibility to address the issue, and we cannot automatically transpose models of first world countries, developed countries to fragile settings. It's a recipe for disaster. There are a number of models and approaches to, for example, legal frameworks such as intermediary liability, duty of care models. There's a big debate in Europe and in the UK right now. But the basic measures that I would recommend in fragile settings are having a clear, accessible legal framework. That's the first step, according to Article 19.3 of the ICCPR, and sharing responsibilities between states, platforms, users, and civil society. and always having judicial remedies, safeguards against platform decisions, and out-of-court solutions as well. And having transparent moderation processes always available for people to know what they are facing when they have these decisions made. So yeah, that's it. Just to conclude, ICCPR is not a panacea for tackling online hate speech. It's just an adequate baseline. It gives us some helpful tools to tackle the problem on a legal and policy level, and it provides us with this workable taxonomy of online hate speech, and endorses a non-binary approach to the moderation of online hate speech, including in fragile settings. So that's it. I'll stop there. Sorry for going a little bit over time, but I hope it was fine. Yeah, just 2 minutes over time.
Thank you. This was a fascinating presentation, so thank you. And the chapter is equally fascinating. So we have a lot of questions. I will try and group them to the extent that I can. But the first is just on the legal framework. So the relationship between the ICCPR and the Universal Declaration of Human Rights. When we speak of Article 19, most people are referring to the Universal Declaration. Right.
So actually, well, the thing with the Universal Declaration is more famous than the ICCPR because it was adopted right after the Second World War. It was signed by, I think, the large majority, if not all states that existed at the time, and there was a lot of commotion around it. But the Universal Declaration is not binding per se. So it's not really international law as it is, though, because of these subsequent human rights treaties and the subsequent practice of states in endorsing those treaties, such as the ICCPR, the American Convention, the European Convention, then some provisions of the Universal Declaration are now part of customary international law. So some provisions of the Universal Declaration are actually identical to the ICCPR. It's just that the ICCPR is a little bit more detailed and it has teeth because it's got human rights supervisory mechanisms and it's binding. So that's why ICCPR and not Universal Declaration, but the two go together.
That actually dovetails nicely with a few questions we got on the enforcement mechanisms for the ICCPR and what enforcement mechanisms are available, particularly when states are non-compliant with the ICCPR. And then one example that was given was, for instance, if the head of state is posting content that is non-compliant with ICCPR restrictions.
So yeah, so the ICCPR does have a different range of enforcement mechanisms, some a little softer, others a little bit more, a bit harder. So individuals can have access to the Human Rights Committee. So they can make individual claims before the Human Rights Committee. That's one avenue, one option, individuals or groups. And the decisions of the Human Rights Committee, though they are not binding per se, they become the authoritative interpretation of the covenant for that state. So this is one way to, and obviously there is the political implication of not complying with the Human Rights Committee decision. And then there are supervisory bodies. So with the ICCPR, you've got the CCPR, and that is a supervisory body of the implementation of the ICCPR. And under that body, states need to submit periodical reports. So every, if I'm not mistaken, every 5 years or so, they submit a report about the different rights that they have to uphold domestically. And then the committee will then assess whether the state is in breach or not, or whether or not there is responsibility. So those are UN-based. And then outside of the UN, obviously, we have interstate enforcement mechanisms. So we have sanctions, for example, which are widely used in the UK. in the EU and in the US. So for example, in the context of, it's not technically online hate speech, but for example, the situation with the Uyghur in Xinjiang, many countries adopted sanctions against China because of its breach of human rights obligations, including under the covenant. And so that's a way to enforce sort of like a more bilateral or multilateral type of enforcement. And you can bring the state that is in breach to court, to an international court. So that's the International Court of Justice. That's possible. I mean, we had the Rohingya case, the Myanmar case, which was brought by the Gambia in relation to, it was about genocide because the court has jurisdiction over the Genocide Convention, but a lot of the incidents relate to online hate speech. And so that's an example of an enforcement measure. And then another enforcement measure, and I'm a big fan of that, is actually tort liability domestically, right? So in the US before, we used to have the ATS. So that was a tort act that would allow foreign tort claims to be brought in the US without any territorial connection to the US, but they have changed the Supreme Court changed the interpretation of that. But in the past, it was possible to bring, for example, before US courts, claims for violations of human rights around the world. And that, well, that's not possible in the US today, but it remains possible in other countries. And even if the legal basis is not the ICCPR or international law or customary international law per se, you can use domestic law that reflects or implements the ICCPR domestically. So for example, in Brazil, human rights have constitutional status. And so, for example, the ICCPR has constitutional status. So one could bring domestic claims for human rights violations before domestic courts under the ICCPR. I don't know if that makes sense, but there are a range of measures. They're not always effective, but there are a significant number of tools.
Thank you. Throughout explaining your taxonomy, you underscore the importance of context in determining which category specific speech falls into. And one question asked if you could explain more how to apply context in determining the proper category for speech, whether through like a legal analysis or just methodologically.
So context basically is more of a common sense, really, analysis that each moderator needs to make. So, I mean, context is a difficult thing to define, even legally, right? And whenever we have a legal provision that says, oh, you need to take into account the context, that, you know, that's an open provision to be applied on a case-by-case basis. So what I'd say is when we look at a certain content, it's a question of common sense, it's a question of experience. You know, if that particular content has generated harm in the past or not. It's a question of the political and historical situation on the ground. So all of these go to context as well. And there are other elements that are related to context, as I said earlier. So you need to take into account, for example, who the speaker is, right? So is the speaker a prominent figure? Is it Donald Trump who's posting this? And are people going to follow him as they have before? So that's part of the context. And if you've got a speaker that has high visibility, then that kind of like tilts the balance in favor of limiting that kind of content. If the speaker has the intention of inciting or infringing upon people's human rights, for example, then that also counts in favor of limiting. And other things, as I said earlier, the victims, who are the victims, and also the audience, right? You know, when we think about online hate speech and speech acts more generally, you're talking about indirect kind of harms in a way, because you always need somebody else. Of course, there is the direct harm to the reputation, to the person's dignity, right? To the victim's dignity. That in itself is a harm. But for physical harm to occur, material harm, you always need somebody to act upon it. So it is important to take into account who are these people who are going to act upon that speech act. And that's particularly important for incitement. And so if in the context you have people that are, for example, in an armed conflict, right, or you've got an economic crisis, these people are eager to fight, there's a lot of division, then obviously that will count towards limiting that particular content to avoid those real world consequences and so on and so forth. So there are a number of parameters that you take into account as part of sort of like the broader criterion that we call, the broader analysis that we call context or contextual analysis, if that makes sense. So it's really difficult to do that, but it's not impossible if you've got clear guidelines to do it, clear criteria to be applied. And it's really also a question of common sense.
Thank you. We had a few questions on elaborating on the distinction between prohibited and limited speech. Do you really view them as substantively different categories, or is there just a magnitude of it that allows something to jump from the limited category into the prohibited category?
So they're actually very close. There's a substantive and there's a procedural difference as well. So the substantive difference is that for things that are not, let's not talk about racial discrimination, because for race, as we saw, almost all kinds of discrimination, hateful expression, racial superiority, these must be criminalized, so they are prohibited. But if you take other protective characteristics, then the difference really is the speaker, whether or not there is an intention to instigate, to incite either discrimination, either violence or hostility. So there has to be some sort of incitement. So that's the key difference. So that's the main difference. It has to be, it's this mindset. Obviously, because incitement is an incomplete kind of act, as we call inchoate act in criminal law, the result need not occur. But there has to be the intention of that occurring on the part of the speaker. So that is the main difference substantively. And in terms of the content itself, so leaving aside the intentionality of the perpetrator, then the content itself could be pretty similar. And in fact, some cases of limited speech, when what seem like limited speech in context could be prohibited speech. So for example, the monkey emoji. The monkey emoji, is it a sign of racial superiority? Some say it is, right? So in some contexts, it should be considered prohibited speech, right? And others, limited speech. So there is a little bit of an overlap there. In terms of process, as we saw earlier, the measures are quite different. So in terms of like moderation, we need to be a bit more proactive when it comes to prohibited content, because states are required to prohibit that. And so they cannot allow that to proliferate. And for limited content, then you need to justify measures for that. I don't know if that answered the question, but yeah, the content itself can be very similar. It's just the intention that distinguishes.
We are at time, so I have one question that came up from many of the participants, which is, are these slides shareable?
Yeah,
okay,
I will share them here. Can I share the slides here?
Yes, and we will be posting the recording from this session as well as the slides on the website for GW's Media and Peacebuilding Project. And really just thank you, Talita, for this wonderful presentation. It was fascinating and very thoughtful.
You're
Thank you
welcome.
everyone for attending. We will have our next seminar in 2 weeks, I believe, and at the same time, and we'll be sending out more information on that. So please look out for that email. And yeah, thank you all so much for your time and your questions, and have a good Wednesday.